Welcome to the Make Each Click Count podcast. This is your host, Andy Splichal, and today we're diving into a topic that many website owners might unexpectedly face, copyright claims. So about 6 months ago, I received a letter from a company called PickRights claiming that one of my old blog posts from back in 2020 used one of their images without permission, and they were demanding $470 in damages. Now, the post barely received any traffic. And quite frankly, I thought it was a scam. I mean, we've all gotten those renew your domain now for like $300 when it'll cost you $35 to do it yourself. So I thought this was a scam. But to be cautious, I went ahead and I did remove the image. I replaced it, but I didn't think much of it. Now, last week, I hadn't been down to my P.O. box for a couple months. And I went there, and there were two more letters from PickRights, along with a large packet from a legal firm, Higby and Associates. And now they're demanding $1,422 for damages and resulting from their clients, and stating need to pay right now, or they'll take me to court where it'll result in not less than $2,500 and not more than $30,000 in damages. So I started doing some research and discovered this is a fairly common situation for bloggers and website owners. So today, I've invited a couple of legal experts, attorneys Eric Bjornstrom and Dan Kimball from kb-ip.com to join us. And we're going to discuss how to handle these kind of copyright claims and the right steps to take and what not to do when using online images. So welcome to the show, guys.
Hi, glad to be
Hi.
here.
Hi, Andy. Nice to see you
Nice,
again.
yeah, nice to meet you, Andy.
Yeah, nice to see you, Dan, and nice to meet you, Eric. So let's start by setting the stage. I guess, how common is it for small businesses or bloggers to receive a copyright claim like this? And have you come across this specific partnership, it seems, between PickRights and Higby and Associates?
Okay, a couple of questions, a couple of things. Yeah, it's increasingly common, unfortunately. And it's always people like you that I've heard from who are very surprised. It's usually an old posting or something that could even be considered a fair use if it's something to do with art or something like that. And they're always shocked that they get these. It actually, the last few I have seen have all been involving this law firm that you mentioned and the company, which I assume is they may have an interest in or maybe holds a license. They might go around asking people to aggregate their rights and that they'll enforce their rights for them. They're probably using even something as easy as Google image search to find out where these things are. I think in the past people would use watermarked photographs, like specific photographers. Like I've worked for a photographer that Dan and I both know in Highland Park, Edward Culver, who did a bunch of the famous punk rock photos from the early 80s in LA, and his stuff gets pirated all the time. And it's legitimate for him to be upset. And it's hard to track it down. And we always talked about watermarking or not watermarking, things like that. But these types of scenarios you're talking about seem to be law firms or group companies that are affiliated with law firms. And as Dan could say, it's similar to what happens in the patent world, what we call NPEs or non-practicing entities, where it's like, you hear the huge patent troll cases, right? And they're not what you would think. Just like here, it's not some artist who's getting screwed out of his money. It's a company that's purchased these rights, just like an NPE is a company that doesn't actually make the item, it doesn't make the patented item, but they're buying the patents so they can enforce them, right? And typically it happens where you have areas of the law like copyright that have fee shifting. So if someone wins any nominal amount of money, they might have a claim that they're going to get their legal fees, and that's what drives a lot of this.
Yeah, another point you should mention is copyright violations can be liquidated damages. So you don't
Yeah,
have to prove your damages. You could just say, "Oh, one incident of copying is worth 2,500, and it could go up." So it puts a lot of ammunition on the part of the copyright owner or a person asserting it, because they can say, "We've got a $2,500 cudgel over your head. So we want you to
yeah,
negotiate for 400." And then what they do is they escalate. and they
Yeah,
figure
and
that,
that's what happened here. It started at 400, now they're at
yeah, that's very
1400.
typical. And then it's a numbers game, so they're probably sending out these letters. No one's really preparing them by hand with careful research. They're just going out probably massive numbers, and then a certain percentage of people will pay right away. So it can be a very highly profitable business for the people who do it. Eric can elaborate more. He's been involved with this a lot more than I have, but I've been on the receiving end with my clients of many of these, and we'll talk about that more later. But it's a very common issue.
So now is this claim legitimate, or is this a legal scare tactic? And how can
No,
somebody tell the difference?
it can be very legitimate. Copyright's a very esoteric area in a weird way. I mean, because of the statutory damages, I'm just looking at what the current statute is. I haven't heard that it's 2,500. It looks like it's still 750 to 30,000. And then if it's willful, it can range up to 150. But if the infringer shows that the infringer was not aware and had no reason to believe, it can be reduced to 200. So you're kind of looking at this range from, without willful infringement, 200 to 30,000. And so someone came out at 470, then that's not even the low level of infringement, 750, which can be knocked down to 200. So they're kind of starting in this little sweet spot where they know that you're going to be rolling the dice almost anything you do. But so it is legitimate because copyright is intended to protect anything that's fixed in a tangible medium. So as soon as you take a photograph, you have a quote copyright on it,
Right.
but you can't enforce it in court until you register it. And that costs whatever, $35, $40. So, and someone can't sue you until they have a registration. So a lot of these guys will register them in a group work, or maybe they're not even registered. So that would be the first thing to ask is hopefully they provide you with the registration number in the letter. But that does allow them to go into court. But courts don't look, you know, they don't look nicely at these kind of claims because they know what they are. But what's it going to cost you to fight that? You know what I mean? That's the problem. You're just looking at a nuisance value. So it is legitimate in one respect, but it sort of perverts the purpose of the copyright law, which was to get these small artists some remedy, right? Because otherwise they'd have to prove damages. And it's really hard to prove damages if no one's ever used your photograph. So we have statutory damages, but by combining statutory damages with fees, it really shifts the weight to the copyright holder to hold you up for anything between, $200 and $2,000, right? It's just not worth you fighting it.
Yeah.
So
Now in the letter that I got from the lawyer from the legal firm here,
right,
but it's encouraging me to give them a call to resolve the issue, and so
right,
I haven't done it. I haven't done that yet.
right,
Because I looked online and I saw some mixed advice. So some people were saying, don't call because they know they've contacted you correctly and then they'll never stop. Or
right.
yeah, call them and see what they'll negotiate down and just make it go away. I guess what would you recommend somebody calling on this situation?
Well, that's the hard part, right? I mean, this is all legal advice at this point that I'm not supposed to be giving out without you being my client because I don't know your situation, right? Um, I've been on the plaintiff side before with a company that does solar panel ads, right? You do click ads, so you know that world, solar ads. And, if someone really wants to fight you on one of these, you have to show ownership. You have to show a lot of things. And like you have to trace that photograph back to the person who took it and make sure that there was an assignment at every point along the way or that it was a work for hire. So sometimes if you really push for all that information, that would be good to know as a defendant. You can really push for the information of,
Now,
okay, well,
yeah, I
who
mean,
took this
will they,
photo,
yeah,
right?
will they give you that? Because that was the other thing that I read was, you should call and ask, to see their license on the image and the
Right, right,
first time they saw it on your website and the last time.
right. Those are all legitimate questions because those are all defenses that you would have in a lawsuit. which copyright law is notoriously sort of picky, right? It's on one hand, it's simple because you just take a picture, you have a copyright. On another hand, I think because of the movie business and all these other things, like you have to really keep track of it, right? So you have to know who took the photo. Was it first question is who took it? Was it a work for hire or was there an assignment? If it's neither of those things, then they're probably dead in the water because they don't have any rights.
Yeah.
And then you could ask for each step along the way, right? Just like a title to a house. Like if you're going to buy a house, you're going to search the title. And you should be able, if there's a registration, to go to the Copyright Office, copyright.gov, and find the registration number, and then look for the assignments and find out who has the title to it. They may say they just have the right to sue, which is a different question, but you could also ask for that proof. And then those are the kinds of things that you could ask, and now you're going to make yourself a troubled case, right? So it may be worth it to do those things to get the number to go down. You roll the dice that eventually these types of people eventually say, well, we have to sue some people so that people don't think that we walk away for nothing. So, are you going to become that person?
Yeah.
That's where you roll the dice. But definitely I would ask those questions. And then as far as what people are asking about when the first time they saw it and the second time, that's because the damages go back, I believe it's 3 years in copyright now. So if they saw it more than 3 years ago, they can't get damages for that.
Oh, because I was reading and it seems to be there's some mixed messages on there that, yeah, there's a
Right.
3-year statute of limitations. But and like the internet,
But
like
the
everything, there's false information, right? And so people
well,
are saying that if it appeared more than 3 years ago originally, then they might not be able to sue you.
no, okay. So yeah, the law's got so many distinctions. So it's a 3-year statute on damages, right? That means they can only go back 3 years on damages. But there was a pretty famous case that came out just a few years ago by the Supreme Court called Petrella that had to do with the I think it was Raging Bull, the script. Someone sat on that script for a long time and then they filed a lawsuit many years later. And the court said, well, they could file the lawsuit, but they could only get damages for a certain number of years because sometimes you might create something and it might not be worth anything and years can go by and all of a sudden it becomes a classic movie and there's a lot of money there. So you should be entitled to enforce your rights, but you shouldn't be able to go all the way back. That's kind of the compromise. So they're not barred from suing you, but they are barred on the far back the damages
Got it.
go.
So, I mean, for business owners out there who might have done, I mean, and
Yeah.
for our blog post,
Yeah.
typically we're using images where we're purchasing. And so this
Yeah.
one, I assumed it was, looked, I could not find it in our subscription. So maybe, somehow one of our VAs
Right.
used it and I didn't know. But
Well,
if
certainly,
somebody's out there
if
who's used them.
you've purchased the image, you
No,
should
and
go
I
back to
couldn't,
the
I couldn't
owner.
find it. I assumed it
Yeah,
was,
yeah.
but I couldn't find it. So I'm assuming,
But
somebody that worked
yeah,
for me just grabbed it offline and,
right.
I
And
had
that
no idea they
yeah.
didn't use my account to purchase images.
And Andy, that's a very good practice. You should not take images like, and you have to be careful. All
Yeah.
these free image websites are usually not free, so
Yeah.
just it's kind of false advertising, I think. But you
Right.
have to make sure you have rights to them. It's an interesting thing now that's happening is people are using like AI image generators
Right. Yeah,
to create
that's really changed it, right?
to create copyright free images, which it's going to create a whole new set of issues because the AI is trained on existing material. So a lot of artists are saying, we're suing the AI companies because you copied all our art to create your AI models. So, but anyways,
but will they be able to sue like somebody like a small business owner or stuff
no,
that's using that?
I don't think so. But again, you're doing the right thing by, licensing images, and that way you can always point a finger, and at least you're innocent because you were doing you're doing it the proper
The
way.
one thing I would say about that though, unfortunately, you have to read the fine print. because I remember a case now that where someone actually did purchase images. It was for a home for some kind of background for a product that they were filming or shooting or something. And the company had basically put in a fine print like you can't use high resolution images, right? We're giving you this DVD, but you can only use these low resolution ones. So then when someone would use the high resolution, oh, you exceed the license, right?
Yeah.
And so you got to be very careful
That's tricky.
when you go to a free site, exactly. And the line's going to usually be commercial. So they could say, oh yeah, this is free for schools and art projects. But if you're going to have click through advertising, and that's where you got to be careful is don't, if it's look too good of a deal to be true, it might be, right? So take a quick look and try and figure it out. And I hate to tell people to read the fine print, but
Yeah.
in copyright, and I get very theoretical. I try not to do that, but basically the way it works is because the rights are divisible. It's like doing a movie. You have to get the song right, the recording right. There's just a lot of minefields in copyright law, so you got to be careful about
Yeah.
that.
So if
But if
somebody's
you bought it, but 1 second would be if you bought it, or even if you got it for free, the service that you signed up for, I would contact them immediately and say, hey, what's up? Because they should make some kind of warranty that what they're giving you, they have the rights to give you, right? Certainly Getty Images or someone like that would be doing that. Some fly by night place, they should still, there's still an implied warranty that it's useful or it's okay for what you got it for. So I would go to them first. I haven't heard of anyone getting approached on that kind of situation. That's pretty shady. So
now, for listeners who might have images that they've just copied online,
right.
but even if they're blog posts from who knows, right? 15, 20 years ago going back,
Right.
could they be facing this kind of issue? There's no, I guess it doesn't matter when it was posted.
Well, it does matter to some extent, but to prove that, again, I would just use that as ammo to get the number down, right? Because the older it gets, the less likely the courts are to really enforce it. And one of the tricks they do is they'll say, if it's an ownership issue, should be resolved within 3 years. Infringement issues, maybe you get damages, but they'll try and make everything an ownership issue so that the court doesn't have to look at it. But
Now this
I
is
would,
yeah,
yeah,
go ahead. Well, I was just gonna
I
say
would,
this is I'm sorry. Yeah, I was just gonna say, so this is a French company too. Does that matter because they have a US based attorney
the French company that what?
that has the rights?
Oh, well, I mean, I would see if they have a registration in the US. That would
What is
be
it?
important.
Agents France Press is the
If
name
they
of the
don't, if they
company
don't
that
have a
has the rights.
registration in the US, I mean, what are they going to do? Sue you in France and like get damages against you? I mean, I'm not sure about. Um, these are all things that make the argument weaker for the plaintiff, right? I'm not saying they're slam dunks, and by the time you talk to someone like me for 2 hours, you might as well just pay them. That's
Right,
kind of the
right,
thing. But you
right.
don't want to be on their list of hit people. And these are questions that you should be asking about the ownership, about the registration. And another one would be some people, like if you're using it for art, like one of these guys that I know got this, was using it for just a kind of a website that talked about, hey, these are the exhibits that are in LA this week, right? Go check it out, right? And he used a photo that happened to be a copyrighted photo that someone sold to one of these guys. And he had an argument that it was like a fair use, right? That it was really just reporting on an exhibit. And that's not always a slam dunk, but
Mhm.
the less commercial the use is, the better.
Yeah,
And that probably doesn't help people in your field. So
right.
there are these claims, and there's also claims like derivative works, like, hey, I just took a little bit of it and put it in a collage, or I created something else with it. Like there's all these things you can argue, but none of them are necessarily slam dunks.
Now
Um,
I thought, once I would take it down, that would be it, because you hear, especially in election season, I mean, some news been heard like where Trump is
right,
playing a song, right? Donald Trump's playing a song in his campaign rally, and the
right,
artist tells him to stop, and if you do it again, we'll sue. Right.
right.
But that's not the case with this. They're not saying taking it down's good. They want
No,
some sort of damages. And I
Right.
guess how do they consider, because again, this is for a blog post that received just limited
Right.
traffic. How are they even arguing what damages were incurred?
Well, that's why you have statutory damages, right? That's what the point of those are, is that in a non-statutory damages case, the copyright damages are lost, your lost profits or their profits that they gained. Those are hard to quantify. And so they have statutory damages, which creates this little amount of money that's supposed to de-incentivize people from stealing and saying, well, I can steal it because they're never going to be able to prove damages. Well, statutory damages and fees, they can get something out of it. So they don't have to prove the damages. That's what Dan said, liquidated damages or statutory damages. Those are the same thing. Those are like predetermined damages that the legislature says, um, this kind of thing we want to discourage. So we're going to give you a little penalty for that. So it is hard to quantify it. I guarantee you if it was, something that was sold like a diamond ring or something that sold a lot, they would go for actual damages.
Mhm.
But the statutory damages on something like this is much more common. Um, and so, yeah, I mean, these are all just kind of like a decision tree, right? Of you're going to argue ownership, you're going to argue how long it's been, you're going to argue that it was fair use or derivative work. These different things you can argue to try and get the numbers down. But you said sue, right? The Donald Trump thing. That's another common thing. You said, well, they said take the song down or we're going to sue you. Well, they probably still got money from it. They probably just gave them like a release. They
Hmm.
didn't file a lawsuit, but they still got money from it. You just don't know about that because it's not in the press because that's confidential, right? So when you settle one of these, you'd want it to be confidential, but they don't have to sue you. They can still get money out of you. And taking it down obviously gets you around willfulness because now you're not willful. So that's good. But they still have the right under the copyright law because you displayed it in the last 3 years to potentially sue you. So when you say they sent you a big package, what was in that package?
Oh, I mean, it's I have it right here. It's a letter just explaining what the other letter said, and it shows it shows a picture of the image on my site and their
But
thing.
it's not like a draft. It's not like a draft complaint, right? Or lawsuit.
No, it's just, yeah, a letter. They have a nice form here to make it easy for me to pay.
Right. Right.
And
Right.
so
Right.
that kind of thing.
Right.
Do they
Um,
include a copy of the copyright registration?
I don't see a copy of, I have the image, but I don't see the copyright
Mhm.
infringing file location. Infringing, but yeah, I do exhibit
It doesn't list the
A.
registration number.
I do not see it. I'll have to look through it again.
So in that instance, they can't sue you then if there's no registration. So that's something to know.
Okay, that is good to
There's
know.
no federal jurisdiction without a registration.
Okay, so
And
I'll
so
look through
that
it for a
yeah,
registration number.
Yeah, maybe a good thing to do would just to ask them for a copy of the registration.
right.
And
Yeah.
then if they can't produce it, they really cannot take it further.
So you would
I would
suggest calling them then, not just ignoring it and
And
hoping it
Andy,
goes
there's
away.
another thing in the copyright law. You can only sue for damages. Well, I'm not sure how it works with statutory damages, but if there's actual damages, you can only go back 3 months before when they obtained the registration. So they couldn't sue for actual damages. I don't know what is the rule, Eric, if they don't have a registration?
well no,
Statutory damages?
they have to file for the registration within 3 months of publication, right? So that's probably the issue if they didn't do
Okay.
that.
So somebody
And that
would
would
want
be
to know what the publication date and the registration.
yeah, the first publication of the work, right? They want you to file. I mean, I have to double check that. Some of these things change, but
Yeah.
this world that you're in is fraught with changes so quickly.
Well, it's
Uh,
interesting. So when I read online on this company apparently has an AI bot that is spam, because you had mentioned using
yeah,
AI images now. Well, they're using AI to find people who maybe have images that they've purchased.
They probably use some kind of software to generate the letters. They're not having people, draft
No,
these
of course,
time
of
writing
course.
these letters.
Yeah.
This is
Yeah,
a
well, that's
volume
what they
business,
said.
Andy.
Yeah,
It's
no,
a
for
volume
sure.
business.
And that's what they said, that this company and this legal firm have kind of made a partnership. And so they said
Right.
they'll never stop because they're just cranking out the letters.
Right.
Now whether they'll ever sue, I guess is a different thing. I guess what do you think? And I know this is hypothetical and you can't give legal advice, but what would be the worst case scenario if I just ignore it? I mean, are they just going to send me letters forever? Or will they actually think, could they take me to court and I'd owe them $50,000?
No, they'll they have to eventually sue some people. And I've seen, this is Higby, I think, right? I think I've
Higby,
seen them
yeah.
filing some cases here and there. I could look online. You can look up the law firms and see if they filed cases, and they're going to have to file some cases. Otherwise, it's just an extortion racket, right? And the courts don't really like that. But what would it cost? It would cost, I
The
mean, if I had
filing
to file,
fee,
if I had to
filing
file a,
fee.
yeah, if I had to file a case, I'm going to want a couple grand, right? Write the complaint. The filing fee's $400. Um, and you're going to get your attorney's fees, but the briefing on that's going to cost money. So, you know, the more you resist, the more the judge is going to give them attorney's fees. Like, I'm trying to think of an example. Like, I've gotten statutory damages and fees on a default judgment where a big company just didn't respond. It was a company that made wall hangings and used my client's art. I think we got 25,000, right?
Wow, okay.
But we would have had to go to Chicago to enforce that, right? We would have had to hire a debt collector, pay him a bunch of money. He'd have to take a debtor's exam, get the judgment domesticated there, right? And so I can't remember what you end up taking some fraction of that, right? And the courts kind of know that. Like they know if they award these statutory damages that you're not really going to collect that. It's just a negotiation. So, it's possible. And that's the other thing you should think about when you think about this is I don't know where that law firm's located, right? But they're generally going to have to sue you in your venue. So if they're in LA and you're in LA, you're kind of hosed, right? If you're in
Yeah,
Maine,
I think they're in Orange County and I'm in
right?
LA, so.
Yeah. So if you're in Maine, right? I mean, they can still sue you there, but or they can sue you here and just hope to get a default that they can make stick somehow, but might not. But if you're in a far-flung place, that's another thing to consider. If you're in Guam, right? To consider negotiating them down. But
Yeah.
they do have to file a case eventually. I mean, I used to work a long, long time ago, like way long ago, when the software industry first started enforcing for really expensive programs. And they had a program. We had a program where it was like first letter was cease and desist, second letter was like a strong cease and desist. Third letter was like we're really going to sue you. Fourth letter was here's the draft complaint. You haven't filed it yet. You know what I mean?
Mhm.
And then they very rarely would file, right? Eventually they have to file because it looks like extortion but they don't want to do it because if they lose, it's very negative press, right? Because lawsuits are public knowledge. Settlements are confidential. So if they lose, you always got to be careful. Now people know that you lost. So
So
I
let me
wouldn't,
ask, yeah, go
yeah,
ahead.
I just can't. I mean, the questions you're asking me is like, what's the bottom line stuff? And I hate to say it, but everything in the law is just balancing, right? It's
Yeah.
just balancing the bottom line and
All right.
trying to,
So let me ask you one more. So what's the bottom line here? If somebody gets this letter and when should they think about hiring their own legal counsel like you guys?
yeah.
When should they make the call to them to negotiate? I guess when do they need more help or when do they just ignore it?
Well, what I would do, I wouldn't just ignore it, but I would take a look at the first few things we talked about, which is, does it look like, what are they alleging about how they own it? Are they a licensee, or something? or do they actually own it? And then do they have a registration, right? And does it look like there could be some problems in the title, right? Like kind of arm yourself with those facts. Then
And if you
I
call them,
would
they're going to give you that information.
I would specifically wait after that till like the next letter, right? Now, that's just me talking,
Now,
right?
would you recommend sending a letter back to them or
No,
actually
I would
picking up
just
the
wait and see
phone?
what happens. They're going to write to you again for sure, right?
Yeah.
And then when they write to you again, then you start asking them these questions, see what they say. I don't know how their statistics work. It probably
Eric,
is statistics,
Eric,
right?
I want to ask you about it's these very common like these
Yeah.
mass copyright omnibus registrations that have like 3,000 images and it's one
Yeah.
registration. How does that work in terms of negotiating or how liable somebody might be for a copyright violation?
No, it doesn't. That doesn't matter. That's just a matter of convenience for filing them. It
Mhm.
just gives you another avenue of attack because sometimes those aren't legitimate if they weren't published in the same year or they're unpublished. The rules on that all has changed too, but it's still a registration.
Mhm.
Um, but yeah, those. I mean, you just have to make sure that the ownership's correct, right? I mean,
Yeah.
if someone peeled off one registration from that, what was the effect of it?
Yeah.
But to get back to the practical thing, I would wait till the second letter at least, and probably contact them and make it look like you're an intelligent consumer, right? And don't let them bully you, right? Because once they caught you, they're going to say, "Oh, you're totally hosed, right? You're going to be paying statutory damages, you're going to be paying fees, and don't yell at them and say, okay, what's the basis for that? Do you have a registration? I live in Maine, like things that are going to make them put you in the trouble list, not the
Mhm.
immediately compliant list, right?
Yeah.
Um,
And so
and
does it make
yeah,
sense to get a legal representative yourself, or is that going to cost you more than what you
I
probably could
just,
settle for?
yeah, I mean, if it keeps going, I think you're going to have to, but I can't in good conscience say, oh yeah, you should give me $1,000 to talk to you, right? For 2 hours. That's cutting my own throat, I guess, but it is this is all a game of numbers, so you want to keep the numbers on your side. Right? So I think once it gets beyond that, or if you have any special circumstances like you made a lot of money on that ad, right? And they can trace that through Google and all these analytics and stuff. If they're going to know you're bullshitting them, right? Oh, I didn't make anything on it. Oh, really? Well, we see you have this many hits,
Yeah.
then you're going to be getting into trouble. And be careful what you put in writing. If you put something in writing, that's an admission under evidence. So you start putting things in writing, they better be true. Because if they're not true, they'll be, what is it? The Miranda warnings, anything you say can well be used against you. It applies in civil as well, right? Everything you say is an admission. That's the easiest evidence in the world to get in. So you got to be very careful of what you put in writing.
Well, this has been really, I mean, it's been great as far as
Yeah,
helpfulness. I don't know.
yeah,
But so if a listener out there, has some legal questions they do need to ask you guys,
right.
I'd like to ask you guys. I mean, you've been super forthcoming and super helpful. But what would be the best way to contact you all?
Just through our website. I mean, Dan, I believe our emails are on there, right, Dan?
Yeah, our website is kb-ip.com. And you
Right.
can find Eric there as well as me. But Eric's
Yeah,
more of the copyright guru at our firm, so he'd be the
right.
right person to contact.
But Dan's the trademark guru, and sometimes these are trademark issues too. So those are a lot more complicated. But
Oh, I beg to differ. Copyright law looks very simple, but it's so I don't really practice that much. It's
right.
a very
But
complicated area of law.
but the people I know of, and I won't name names, who do these mass lawsuits like this on copyright, they try and get into trademark, and they lose their ass because of the legal the
Yeah.
fuzziness of the law, right? The eight
It's a totally
factors,
different area of law than
very
copyright.
expensive.
They get confused.
Yeah,
Copyright law and trademark law are totally different. They're both IP law, but completely different.
right. Yeah. So,
Well,
yeah, that's how you would contact us, and the phone number's on there. I think when we first started the firm, we didn't have the emails because we were worried about spam, but I think we have them now, but we certainly have the phone number. Um,
great.
so
Well, this has been, immensely useful, and I'm sure listeners
I
who
hope so. I don't know. It
could be
sounds pretty
going through
theoretical.
the same thing.
Yeah.
You can use it or will use it as well. I guess, is there anything else you'd like to add before we wrap it up today?
Yeah,
I just,
I could tell you, in my experience, most of the time I am polite and I drag it out and we end up not paying anything. That's been kind of my experience. They
Right.
have acquired attorney's fees, but they haven't had to pay. And some of these were like, you violated our software, and they were asking for a lot of money. And we kept asking for information and dragged it on, and they just kind of, they just disappeared after a while. It's happened in several cases, but that's not a guarantee would happen in any particular situation. But sometimes being polite but dragging it out is a good way to handle them.
Man, it's
Yeah,
a
and I hope,
nuisance.
I hope that we've armed you with at least the right questions to ask, you know.
I think
Um,
so. I think so. So yeah,
and be
no,
careful up front, just get licensed images and
yeah,
then go
that's
back to
the
the
best
licensor.
advice. Yeah,
Yeah.
for sure.
Go back to the licensor and say, hey, I got contacted. It's your problem now.
Yeah.
So
Cool. Well, thank you guys for joining us today.
yeah, no
Thanks.
problem.
See you again soon, Andy.
For listeners, remember, if you like this episode, please go to Apple Podcasts and leave us a honest review. And if you're looking for more information regarding connecting with our guest today, you'll find the links in the show notes below. In addition, if you're looking for more information on growing your business, check out our podcast resource center available at podcast.makeeachclickcount.com. We then compile all of our different past guests by show topic in case you would like more information on any of the subjects in previous episodes. Well, that's it for today. Remember to stay safe, keep healthy, and happy marketing. Talk to you in the next episode.